All right, everybody. Welcome to the Creative Finance Collective. It's 3:00 Arizona time, so we're going to be taking questions throughout the hour or until we cease having any questions. So, if you're just now joining us, what is the Creative Finance Collective? It's an opportunity for lawyers like myself and others throughout the country to discuss all things creative finance related. So, if you have questions, make sure to post them in the chat. Also, for anybody who's watching not on YouTube, so on Facebook or on Twitter, known as X, the best way to follow us at the NREM podcast or at the collective is on our YouTube channel. I have a barcode right at the top of the screen called NREM podcast. You can scan that, takes you right to our YouTube channel, subscribe, and that'll get you updates and easier access to the collective and asking questions, so on and so forth. So again, if you have any questions, make sure to post them in the chat. We're taking questions for the hour or until the questions run out. So if you run out of questions, we run out of interest to be on live any further, except getting to know each other. But I kind of feel like as many of these as we've done, we kind of know everybody. So we've got, in addition to myself, Sean St. Clair, Alan Seschker in Texas, and Drew out of Georgia and Alabama. Drew, I haven't seen you in a little bit. You said it was cold up
Yeah,
in
it's
Georgia.
it is. We're getting down to 15 degrees Fahrenheit tonight, which is a lot colder than is meant to be here. So you better believe I've got faucets dripping both in the office and at home, and I've let my tenants know you better have the faucets dripping at your offices too.
Now
I
that's
have you beat.
yeah. I was just gonna say that sounds cold, but I'll bet it's cold where Shot is.
It'll be in the negative tonight, and the high today I think was like 4. So it'll be -7, -8 tonight.
Yeah,
like,
no, thank you.
What's it like in Texas, Alan?
We have a balmy 11 last night. We're getting 1 degree above freezing today, though.
Oh, wow, colder than I was. I think there's been a some sort of system going through. Everybody's been cold. Arizona was really cold last week, and I know that's when I say really cold. You know, it was warmer than 11 degrees. I'll say that it wasn't that cold, but I guess we had. I know it's cold where we live when we have these frost lamps that are triggered to come on in the event it drops below 32 degrees for the citrus. And in the last like 3 or 4 years, those frost lamps have only come on this year for a few nights. So we had a few nights that were frost warning, but we don't get that cold. So what's going on in the creative finance space? What's it look like in Texas right now? Any new issues popping up, Alan?
Well, I think I mentioned this a couple times ago. One thing that we're seeing is a little bit more attention to the due on sale clause, not necessarily paying attention to the conveyances, but noticing the conveyances when the insurance comes in. And so I don't necessarily want to name names, but one loan servicer has hit us about 3 times. And so we're going back to the trust vehicles to disguise that.
I know we've talked about that. So is that, maybe you just said that, recently popped up again?
Yeah, we've since we talked about last time, we've had one. And I think I told you all about the effort to kind of move mortgage wraps over into the mainstream.
Mm-hmm.
And that's relatively successful so far. And I guess the resiliency of these consumer users isn't the same as investors, and so they're hypersensitive, and they want the trust structure set up from the get-go. So we're kind of shifting and pivoting a little bit with them. I don't know if it's needed or not. Just keeping an eye on it and watching what's going on.
Interesting. So we have a couple questions already. Let me pose this to you. I think it's a general question, but we can tie this into creative finance. because I know Alan and Sean, in your creative finance documents, we require both of these. But the question is, how do you get a power of attorney? Question mark. Is there anything I should look out for? Question mark. Now, that's a pretty general question. I know that really the main way you get a power of attorney is you ask for one. Then it boils down to whether you're using the appropriate form and what to look out for. Maybe before we get into that, you guys might want to explain the importance when you use powers of attorney in a creative finance transaction.
So, Sean, I want you to go first.
Sure. So it can be used for multiple things. For example, more recently, we've had situations come up where our clients have closed on transactions, and then a couple of years back, they've been paying the escrow impounds, and then the impounds are then refunded. But instead of following the instructions that are delivered to the lender that either says apply it to the loan balance or cut a check to this particular entity, they cut it to the seller. And so a properly drafted POA allows the buyer in that case to endorse that check and make it payable to them, because it's their money at the end of the day. And there's an assignment of all insurance proceeds and other amounts that are executed at closing. So that's one example. The second would be to procure insurance if need be, to cash larger insurance checks like property damage and things like that. And then also to deal with situations where even you may need to use it for escrow purposes at a later date if something didn't get done right, or there's a title issue and you're wanting to sell the property and you can't track down the original seller to get their cooperation. What about you, Alan?
So you hit all the high points. We get an authorization in there and we change all the contact information, phone number, address, email address to the investor buyer on a subto acquisition. And then on the power of attorney, just like you said, the authorization to endorse the back of a escrow refund check, although it's probably not needed, the authorization to endorse the back of an insurance claim check. And then also I added in there and deposit into the account holder XYZ investor. And that actually came up just recently. The bank, usually when you take your power of attorney to the bank and say, look, I have this, let me do it, bank says no. This bank said, no, it doesn't say you can deposit it. And I looked back and fortunately it did. And so they actually allowed it. I will say that a fallback is to take your power of attorney over to one of the check cashing places. And they're a little bit more lenient in regard to power of attorneys. But you hit all the high points that I have in mind.
Right. And I see there's a couple of uses of the power of attorney. So in creative financing, I don't do as creative as you guys do, so I don't see it as often. But I deal with POAs regularly. I have a lot of overseas sellers and sometimes borrowers. And so obviously we use POAs, but of course, being overseas, we fall into the apostille rules and, getting things vetted for the United States' purposes. But obviously, the big picture of the POA is if this person's looking and based on their questions, they may not realize we're not talking about a bog standard POA. So I shouldn't say most, some states, such as our state, has a statutory durable power of attorney. I know Alabama does as well. That's not what you're looking for if you're engaging in real estate transactions like this, right? Like what these guys are talking about. You're looking for a very specific power of attorney. And of course, in my case, it's obviously limited specifically to a property and has a limited duration. And generally, the agent signs on behalf, like the real estate agent for the overseas investor. In their cases, they're designed specifically for their creative financing transactions. That's why Alan was saying, you have to make sure there's the power, to deposit checks, right? That's something, because I run into this as well. Lenders will sometimes just deny POAs out of hand. but they have to be careful denying POAs because some states, again, Georgia and Alabama, as representative of the two, there are statutes that say if they wrongfully deny a POA, they owe damages back to the agent, right, for preventing them from being able to utilize the power of attorney. So the first thing is you got to figure out which kind of POA you have or what kind you need, and then make sure that it's crafted specifically for it. So, you're not putting yourself in the firing lane by having more powers than you really should have, and something goes wrong and you get blamed for it. It's not really a power of attorney per se, but some of our contracts here the assignor will obviously retain certain powers, or they have a power of attorney that's granted to them by the assignee, right? I mean, it's just an assignment, really, powers, not really a POA in the typical sense of it, but it will allow them to continue to negotiate with the seller as buyer. So even though that's not like what you would call a POA in the sense we're talking about a power of attorney, it's the same kind of thing in that one party is granting the power to act as an agent on behalf of someone else. So I just want to try and broaden that scope and hopefully clarify a little bit.
All right, thanks, Drew. If you're just now joining us, we're taking questions for the hour or as long as you all have them, and we're taking questions on creative financing. We've been talking about powers of attorney. If you're new watching us from Facebook or whatever else, we have this little barcode at the top which directs you to our main channel, which is on YouTube. So if you want to follow the collective, follow the NREM podcast and get updates, so on and so forth, scan that barcode, go right there and subscribe. We have another question. It is real estate related. What makes a property condemned? Anybody want to take a crack at that, other than maybe an order from an official, the proper government agency formally condemning the property? What does that process look like?
I don't deal much with it, but I agree with you that when the city says it's condemned, it's condemned. But I don't deal much with it.
No, we've had several files recently where the city of Atlanta, they show up, they post that thing on the door, an order for condemnation and demolish. And then in our case, they always file a lis pendens, right? Obviously, they file suit and then they file a lis pendens, referencing the suit. And then at the end of it, they'll come out there and they'll tear down the house, and then they'll file another, judgment for the recovery of costs for demolishing and hauling off all the trash. And so that's something that we occasionally have to deal with here. In fact, I just had one where we paid last year it costs about 20 grand in Atlanta if they take it down. And we paid it last January, but the city never credited it. And of course, the buyer is now being foreclosed on. And so the lender reached out saying, hey, why wasn't this cleared at closing? Unfortunately, I had all my records to say, no, we did actually pay it. But to Alan's point, it's condemned when the government entity says it's condemned. And generally, in our case, it's followed up with a lawsuit and a lis pendens. So title is very much on notice that there's a condemnation proceeding that has to be resolved. And in our case, we have people that buy it, right, and we're intending to fix it up, and they recognize that it's going to be an exception on their title policy, right? You are buying it subject to this action for condemnation and demolition. And, if you can get it fixed and get it released, great, but title is not protecting you from that. Just throwing that out there.
What's interesting is in the commercial setting, condemnation or eminent domain can be big dollars. I used to practice law with an attorney at a firm in Phoenix, and all he did was eminent domain work, and he did it on a contingency fee. And he basically, whatever the initial offer was, he took whatever percentage. He took a percentage of the difference between the final amount that he obtained for the client and the initial offer by the government, because they always lowball when they start. And then especially commercial, if you can prove the highest and best, because they have to pay out on the highest and best use. And so if you can establish the highest and best use adds $2 million to the value of the land they're trying to, acquire, then, you can do quite well from an attorney perspective and even from a client perspective, and get a lot more money for your dollar by challenging those eminent domain amounts that they're willing to pay.
stuff.
Right. And in some cases it's not, and I think that's where Walter's going. He's not talking about like condemnation in the typical context of the government's taking the land to repurpose it for someone else. And Walter, correct us if we're wrong, but I think he's talking about like condemnation like we have here, where this house is in terrible condition and we want it gone and demolished, right? Which is typically how ours work in Atlanta, at least in the wholesale space, or these things are non-habitable and they're non-functioning. If you don't tear it down or fix it up, we will tear it down and charge you for it. And so that's a form of
Yeah, I guess it,
condemnation,
it
demolition that we
depends
did
how
here.
he's using the
Yeah.
word. So yeah, I guess for properties to be condemned, that means, I don't know, Andy, do we have I know we do code violations, but I'm not aware of any authority of the government to actually condemn real estate in Arizona. Are you?
No, I'm not. No.
Yeah.
I've run like you said, I've run into this more often in the eminent domain context.
Right.
Well, always in the eminent domain context than I have just dealing with a municipality trying to formally condemn a property. But
yeah, I've never come across it in 20 years of practice.
Yeah, not ever litigated or dealt with it in court. I think there's a universal consensus among all of us folks here that it's a procedure brought by a municipality or a government for specific purposes, depending on what local statutes require for that property. Up in Georgia, Drew, I know you're more transactional, but what's the timeline on a process like that you were explaining there?
So I had a file that we got last May, and it finally closed in December. And it had one of these demolition, Liz Pendens filed. One of the properties had already been demolished and had, again, it was an 18, it's around 20,000 for the city of Atlanta to take it down. And the other property had the Liz Pendens filed. The lawsuit was filed in the middle of November. And the Liz Pendens was filed at the end of November, and of course we closed in December, and we caught it. And our buyer is a nonprofit that rehabilitates downtowns or whatever, and so they were fine with it. They already knew all the parties over in that department. But when talking with them about it, they're like, we just don't want any fees to creep up. But they know that it takes 3 months to get the judgment, right? And then after that, but just they don't want to actually demolish the property, right? Like they don't want to go through the cost and expense. So they're not trying to speed it up. They're just kind of slow walking it. And I've had other clients down in Bibb County where if you will just show up and say, hey, I plan to fix this, like they will intentionally drag it out to give you time to try and get it fixed. So I think in my experience, you're looking at like 6 to 9 months before they'll actually be like, all right, we're going to go out there and tear this down. At least that's been my experience, is if you reach out and let them know what you're doing, they will not try and push it forward, right? They will kind of hold off and give you time to fix the property up.
So we have another question. I like this question. It's going to sound pretty general on the front end, but there's a tie-in to creative finance. But the question is, what makes a legal document legal/binding? And the first thing that comes to mind when I think of that question is, well, a document that comports maybe with all the statutory requirements to the extent that there are some. For instance, like a will. If you're in a state that requires 2 witnesses and your document does not have the statutory requisite requirements that meet what a will would be, then you don't have a legally binding will because it doesn't meet that, and so on and so forth. But one of the interesting things that I think about when considering that question is in the area of contract law, and specifically creative finance. Of course, what is legal and binding within a contract is basically what the parties agree to and what they decide upon and are willing to exchange consideration over. And the only thing that would make that document illegal is if it contains some sort of provision that was by operation of a law illegal or something to that effect. But I guess the tie-in here for creative finance is one of the knocks that I think the uneducated in a creative finance transaction, we've had entire episodes, Sean and I, about this, is, well, that's illegal. that transaction's illegal, they'll say, because usually because it violates the due on sale clause or whatever else. What would you all say to what makes a creative finance transaction legal? Is it just or binding and enforceable? Is it that it's comes down to it's the agreement among the parties that transact?
Well, I'll jump in with a couple things I've seen. So here in Texas, contract offer, acceptance, consideration, and then you have a binding contract. We've run into situations where buyer does not pay the earnest money, and then they say, "Well, we're not going to go forward with this thing," and they think they don't owe that earnest money anymore, but they certainly do. And then we just saw a situation. Investor sent unsigned contract over to seller. Seller signed, sent it back over to investor. Investor signed, but didn't send it out to the other party. And so no notice of acceptance meant that contract was no longer binding because the seller then, prior to receiving the signed contract, terminated. So essentially withdrew their offer. So that's I guess one thing that comes to mind is when you have all the elements, kind of like you were saying, when you have all the elements together, then you have a binding contract. But if one's missing, then you can start having problems.
On our side, it's exactly what you said, is are you meeting the statutory rules? Because sometimes there's really weird quirks I've noticed, practicing in 2 different states. And I actually had this come up in a file that's closing now in a commercial context, is for our title of course, no one follows this rule, but statutorily, corporate documents are not considered valid unless it's signed by the president or vice president and attested by a secretary or vice secretary, right? So if you're missing the secretarial attestation, technically you are out of compliance with whether or not you have a binding, valid corporate anything document. Now, obviously, no one ever does the secretarial attestation unless it's something I'm drafting, right? But I have a file where it's an Arizona corporation as the seller. It's a big home builder. And, obviously all their stuff's pre-signed all the time, and it's missing the secretarial attestation. Now, the statutes are written in such a way that our requirement for having the secretarial attestation is not something that would apply to a foreign corporation. So I don't know. Does Arizona require a secretarial attestation to have corporate documents be binding? But again, no one follows it. But there's what the rules say, right? And then there's what title lets you get away with, right? Because you almost never see that attestation. So I think it's just interesting that interplay there. But like Alan said, I mean, you have offer acceptance consideration. Like, I mean, if it's just a normal run of the mill contract, there's something there. The parties need to be bound by it, but you can always get tripped up if you're failing to meet these, sort of statutory quirks, which is why it's really important that you find a lawyer licensed in the jurisdiction you plan to do business, because they should be aware of whatever little weird quirks you've got about it. Another one that drives me nuts is our our notary attestation requirement for Georgia, as opposed to everyone else just uses acknowledgments. And of course, California has their own acknowledgement form, which is completely invalid in the state of Georgia. And so they have to have the Hancock form to get around it. So I would just throw those points out there.
Yeah, very, very interesting. And of course, there's what's a legally valid document, and then there's what courts will enforce sometimes as well. I think of Arizona has a unique statutes wherein they will penalize unlicensed contractors. So an unlicensed contractor enters into a contract to do work over a certain amount. It's over like the handyman exception. So I think it's probably over $1,000, assuming you don't have a license and you contract to do that and you get stiffed. Well, that contract probably met all of the elements required for an enforceable contract in the state of Arizona, but Arizona has a statute that penalizes contractors who operate without a license, basically effectively prohibiting them from bringing an action to enforce their rights under that contract, even if they've did all the work and they got stiffed. So I guess even more to Drew's point, sometimes the four corners of the document are perfectly and appear to be perfectly legal, but depending on behind the scenes circumstances, there could be statutes or case law or whatever else that restrict the enforceability of it. If you're just now joining us, it's the Creative Finance Collective. We're taking questions for the hour until we run out of questions. So if you have them, make sure to post those. At the top of the screen, you'll notice there is a barcode for the Interim Podcast. That's a link to our YouTube channel. If you're watching us on YouTube, you don't need to scan that. But we have people watching us on Facebook as well as X, now known as Twitter. You scan that, and that'll take you to our main YouTube page where you can subscribe and have an easier time following what we do and being a part of what we do every Tuesday. We have another question, not necessarily creative finance related, although I guess you closing attorneys could have seen some of this. Have you guys ever experienced a tax deed? By tax deed, I think what that question means is in Arizona, we'd call it a treasurer's deed, but a deed following a tax lien foreclosure or a county tax lien foreclosure. Do you ever run into any of those, Drew, up in Georgia?
Oh yeah. And to yes. And to Sean's point, having you have attorneys that are really, really specialized. There's an attorney that I recently dealt with on a file where his entire practice area is the excess funds. So there are investors who will not buy the tax deeds, but instead they will track down the delinquent tax debtor and they will then buy their interest in the property, right? So in Georgia's a penalty state, right? So the tax deeds tend to actually, like for a valuable property, like they tend to be a lot of money, right? I saw one time a commercial condo. It had, kind of a tax value of like $200,000, right? So at the tax sale that went through, somebody bid $160,000 as the taxes for that. And that's because Georgia is also a 12-month state, right? So it's a 20% penalty state, right? So as soon as that tax is over, they're getting, a right to a 20% on their 160 that they paid. In addition, if it's not redeemed within 365 days from the date or whatever, then you can go ahead and foreclose the right of redemption and you can take the property. It's a pretty fast system, and at least compared to Alabama, which makes you wait 6 years and is an interest only state. There's no penalty, right? Interest accrues at a very low rate comparatively. And so taxes can be a lot, and there can be a lot of excess funds. So there is an attorney that specializes with his investors, and they go around and they don't buy the tax deeds, they buy the interest of the tax debtor. And then that investor goes to the county and files for the excess funds claim, right? Because the taxes were only like, maybe $5,000, but they're holding $160,000, right? And so they can basically go and petition the court to either redeem the property and use the excess funds to help kind of pay it off, and they just bring a little bit and they get the property back, or they can just hoover up that $155,000 less expenses and walk off into the sunset with it. So there are some really, really interesting niches that exist, and tax deeds are an area that's ripe with it. We also have, I forget what they're called, I haven't dealt with them in a while, but we have basically these quasi-governmental entities, housing authorities, right? So normally, in order to clear a tax deed, you have to do a quiet title. And this fouls up a lot of closings on the transactional side. But if the property is being sold through a housing authority, like a chartered housing authority, and they bought the tax deed, then by virtue of their ownership, and depending, again, this is Alabama versus Georgia, but depending on the way in which they held title to the property, their ownership in and of itself can actually clear title. And you don't need to do a full quiet title, right? Because you did like a public sheriff's deed sale as opposed to just a normal, tax deed. So there are investors in this space. There are attorneys that specialize in this, and some people make a living at it. It's not necessarily creative financing, but it's definitely very creative.
Yeah, Alan, do you see investors do that kind of thing in Texas, or you ever run into anything similar?
Yeah. So I've seen three of investors going out there and doing that. And they are extremely lucrative, successful investors. I met with one, and he was extremely cautious when he was meeting with me, and I tried to convey to him, you've got attorney-client privilege on this thing. But I think in order for a business to get up and going and running, you have to have some pretty tight processes and systems and things like that. So he was very, very sensitive in talking about how his business worked. But I've seen a couple, and they're having a good time.
So in Arizona, our system's a little bit different when it comes to tax deeds, in that on any property, but primarily residential, our taxes in Maricopa County are pretty de minimis. I mean, we don't have significant taxes, 1,200, 2,000, 2,500. It's not much per year. And so you basically, to pick up what we call a certificate of purchase, similar to what you were describing, Drew, you go and you bid, and the winning bidder is the one that will accept the lowest amount of interest on the tax amount. So if they bid, say, 2,500, because that's how much was owed, they say, I'll do 2,500 and I'll accept 2%. Then they have to hold that for 3 years. And if at any point the lender, an interest holder, the owner, a beneficiary, or heir of the owner comes out of the woodwork, they can simply walk into the treasurer's office, say, okay, it was 2,500, what's 2% interest? They figure it out and they deliver a check to the treasurer, they redeem it, and boom. And they have up to 3 years to do that. And if they don't, then they can foreclose it. Well, there's this attorney in town who not only does he foreclose, but this guy, he knows this stuff so well. What he does is he looks for these treasure deeds, then he goes and pulls the court records and then cross-references the court records with, say, the treasurer's office, with the heir information. He'll do an heir search, and if he comes up with an heir and he thinks that he can argue that the original attorney foreclosing didn't do the right due diligence in identifying, they have to do reasonable diligence, which includes searching the treasurer's records to see who's paid the taxes in the last, 5 years, 7 years. If he sees that they've not done that, he'll track down the heir and then offer them an amount for like a quitclaim deed or warranty deed to the property. He'll get that. He'll go into court and motion to set aside the judgment. And what's interesting about this is we have case law in Arizona that basically says that if you get a judgment, but you don't properly name and serve all of the right parties, it doesn't matter how long after the judgment somebody sets it aside. It could be 5 years. And you don't have a valid judgment from the get-go. And so somebody can move to set aside. So he then goes and sets it aside. And then once he gets it set aside, he quiets the title as to the buyer of the property at the, via the treasurer's deed, or whoever bought the tax lien and foreclosed on it and got the treasurer's deed. Any lender, he'll name the lenders. And of course, what do? They place title claims. And then he ends up settling for, because they're, of course, now going to, protect their interest. And they end up writing huge checks to this guy, as a result. It's a really interesting thing. And he's the only one that I know of that does that here in Arizona. But he makes really good money doing it.
Yeah.
Which is why I don't do these. Andy will do them. I don't like to foreclose tax liens because I'm like, this guy's going to be looking at my documents here and trying to figure out a way that I messed up,
Yeah, and that's why underwriters, I know that Fidelity, they will not actually underwrite any tax deed that appears to involve a decedent's estate, because exactly to your point, if you don't serve all the heirs, then, it can be attacked. And from their risk perspective, it's just not worth the risk. Now, of course, there are other underwriters that do. And of course, you're dealing with tax deeds. You're generally dealing with very low value files to begin with. And to them, it just doesn't, the risk reward doesn't pan out for them. But it's the same thing in Arizona. And like Arizona, Alabama, a few years ago, it used to be 1% per month, right? And we didn't have to wait 3 years. We had to wait 6 years because we had case law that said, look, basically you have 3 years to attack, but then you gain an additional 3 years for some other purpose. So it pushed us to 6 years. And Alabama's more recent law is the same as yours. Instead of it being, 1% per month, it's now whoever's willing to accept the least amount of interest. Only instead of waiting 3 years, you have to wait 6 years before you can get good title to the property. So they're also making it a bit less lucrative. And because Georgia's is the way it is and it's so fast, is the entire Atlanta market is cornered by a company called Investa Services. So just know if you're in Fulton County and there's been a tax sale of taxes, just go ahead and get ready to deal with Investa because I think they fund the county. Of course, it's owned by a giant like Christiana Trust or whatever. It's one of the huge like private trust companies is the owner of Investa. So it's their market to control. And you can tick them off because I've had some clients that were like, we're going to get in the business, and Investa crushed them because they got more money to pay for it and they don't really care.
Good stuff.
So let me jump in a little bit with Texas and ask y'all: do y'all have any kind of restrictions on these assignments of excess proceeds and things of that nature? Because in Texas, there's a very detailed litany of things that you have to comply with in order to be able to assist on these excess proceeds, and one of them is no solicitation. So it kind of takes the investing out of that. Do y'all not have that?
So I have, after I saw how this guy did the excess funds case on this little file, right? I tried to figure it out. I still don't know how he does it because we also have restrictions. And I don't know if it's because it involved a decedent's estate or what, but our rules are pretty clear that you have to be the named, you know, uh, tax debtor, or you have to be their licensed attorney. Like you can't assign your right to a third party. But in this case, our tax debtor was dead. And so he tracked down the father and he bought the father's interest. The problem is the mother also survived the son and then subsequently deceased. So we also had to go track down a half brother and get his interest released as well as part of it. But we have really strong restrictions as well. And I haven't quite figured out how that attorney pulls it off, but he's apparently known in the courts for these types of actions. So he's figured it out.
If you're just now joining us, this is the Creative Finance Collective. We're taking questions relating to real estate, creative finance throughout the hour. If you have them, go ahead and post them in the chat. Also, if you're just now joining us, we have a barcode link to the NREM Podcast Collective YouTube page, which allows you to go there, subscribe if you're not on YouTube, so you can get better information about that channel. Another question, what's caveat emptor? Just buyer beware. Does anybody have anything else to add to that, or is there any tweak or nuance to your particular state that you find interesting about buyer beware? I guess sometimes in some states it's limited, limited in its application. We like to think of like buying as is as like this thing where you can just straight up buy
As is where
something
is with
as
all
is.
faults disclosed and not disclosed.
I mean, in
Yeah.
Sean, you could probably speak to this to Arizona residential, but I'm not sure as is what most people think it is in places like Arizona, right?
Yeah, there is no as-is sell in Arizona. If a seller knows or has reason to know of a defect with their property and they don't disclose it, they're liable even if the buyer waives, disclosure, inspection, agrees to buy it as is, where is, with all faults and all that fancy language. It doesn't matter. The seller has to disclose, which is why I don't like, if I represent a seller, I'm like, no, you're not going to sell it as is. You're going to give a disclosure statement. You're going to give them an inspection. You're going to do all this, because if you don't, and there turns out to be a problem, it's worse for you than had you just gone through and given them everything that you know about the property, as well as the opportunity to inspect. So yeah, there is no as-is transaction here in Arizona, both commercial or residential.
Is as is a real thing in Texas, Alan?
No, same as what Sean was saying, and I was going to add, a lot of times you'll have investors on ABBC flips, or they purchase a property, sometimes even sight unseen, and then they're out selling, and they say I'm exempt from providing a seller's disclosure, just like Sean said. No. You want to give one. You want to give a big giant seller's disclosure and say unknown, unknown, unknown. When you say I'm not required to provide one, you're wrong under the property code, and then they can start hurting you.
Yeah. What's it like in
And
Georgia, Drew? Is there any?
and on our side, yeah, everything gets disclosed. I said we have GAR forms that, I mean, I think we have too many disclosures, right? Just because it makes, some of our residential contracts span, depending on the number of addendums you have, because of, the type and what's going with it and what's not, it can be over 30 something pages long, which is really long in my opinion for a residential transaction. But no, you need to disclose what you know about the property. And I actually had a file in Alabama years ago, and again, I don't do litigation, so I handed it over. But it was communicated to him that the property was not in the flood zone. Now, and he bought cash, and then the basement subsequently flooded. And it turns out he's in a pretty severe flood zone. Of course, he should have known since he overlooked a creek. But his agent had represented to him that it was not in a flood zone. And she made her representation based on the MLS, because the MLS specifically said it was not in a flood zone. And the MLS said it wasn't in a flood zone because that's what the listing agent said. And the listing agent said it wasn't in a flood zone because that's what the prior MLS listing agent had said. And so they found themselves in a very nice big lawsuit together. Over the fact that they had relied on with the MLS's representation with respect to being in a flood zone.
Another question, what's the best way to look up statutes and laws for a state? Well, you can hire a lawyer who has access to Westlaw or LexisNexis, and we pay heavily for access to those platforms, which allows us to search federal and state statutes, case law with regard to it, whether it's old law, good law, and court cases relating to the law. But if you don't have access to that, in Arizona, and I think this is probably the case in just about every state, the legislators, at least in Arizona, the Arizona State Legislature has a pretty easy website to access. It gives you access to every single statute in the Arizona Revised Code. So that's the way that you do it. I suspect that that's probably the way you do it in Texas and Georgia. It's probably not that hard to access it.
Yeah. And then once you find the statute, you can start trying to find law firms that actually discuss those statutes. And there's a lot of good material on the law firms' websites. They're usually designed to give you enough information so you need to go hire them, but you can learn a little bit more by searching that statute specifically.
Yeah, good stuff. Another
Right.
question.
Well, I'd like to mention an interesting thing, because you are talking about interesting things. In Georgia, we don't have just the code. We have the official code of Georgia annotated, which contained all of the annotations. And it was published by LexisNexis. And LexisNexis claimed that they own the annotated version, as that was the only official code. And so there was a lawsuit here, and it finally resolved a few years ago, and all the way to the US Supreme Court, because the official code of Georgia annotated is the official code, including the annotations. And the Supreme Court said that you can't block like the actual laws behind a paywall. And so it was an interesting lawsuit here. So the annotations are really important for us because they tell us how these laws are supposed to be applied, right? But you could only access them if you paid LexisNexis for the right to read the full version of the laws, even though the legislature used and always cited the OCGA, the annotated version, because that was the official code of laws. But it was locked behind a paywall until the Supreme Court said you can't lock your official code behind a paywall. So now our code is a bit more easy to access.
Interesting. What happens if someone buys and sells your property without your permission? Well, that sounds like fraud. It's hard to sell property without your permission. I know in Arizona, and I think this is probably the case in a lot of states, if somebody fraudulently conveys, because really to sell property is going to require you would assign a deed. So either somebody has the ability to sign on your behalf, like a power of attorney or something else, and they're abusing that power, or they've straight up just have signed your name with no authority and just committed an act of fraud. Um, that's going to require some undoing. That doesn't get undone overnight and would require um, a quiet title action in Arizona to undo that. We don't see that too often unless you're dealing with maybe like sovereign citizens or something. What you see that very often in Texas, Alan? I know you don't
So,
litigate, but you probably run into problems in title as you're trying to close.
yeah, absolutely. And it's, you know, we're just one company in Texas, and we've seen 3 occasions with someone trying to come and fraudulently sell someone's property. They're usually targeting properties that don't have a mortgage, and they also want to take the contract over to an attorney title office versus a corporate title office. I don't know why, and they're getting pretty tricky. We had one guy, and everything's always remote, and they'll hire a real estate agent, sign the contract, and we had one guy that somehow had the correct driver's license of the real owner. And so we get bulletins from the underwriters that tell us, be very, very careful when you have, this criteria. Everything's been handled remote. Real estate agent hasn't met the seller. There's no mortgage on the property, because if there's a mortgage on the property, their game is going to be found out, because a payoff request is going to be needed, authorization is needed, and so that stops them. But I've seen 3. And again, we're just one small little company in Texas, so it's more prevalent than I would want. I tell you that. So it's a problem.
Yeah, and to Alan's point, that's why they're not going to the corporate outfits, is because, just like he said, all the underwriters are sending bulletins with some frequency now about the uptick in fraudulent sellers. And to Alan's point about how much craftier they are becoming. Um, I know some of my wires raise a lot of eyebrows because a lot of my sellers are overseas, and in fact, I just got a new one, and talking about overseas sellers and fraudulent notaries as well. In my case, I'm fortunate that I know who my seller is because they bought it from the builder, and they used the builder's management company to manage the rental for the last 3 or 5 years, and they used the builder's real estate agency to sell it. So all I have to do is reach out to the property manager and say, hey, is this the same person you've been dealing with for the last 3 years? And they're like, oh yeah, that's so and so, he bought it. So we have a very clear chain of ownership. But we had a fraud that tried to be perpetrated on us in August, and it was a relative. It was the brother was wholly unaware. Or I shouldn't say he was wholly. He was aware that the other brother and the girlfriend were trying to sell the property. And I probably told you all this back when it happened. And they tried to fraudulently sign his name, and this girlfriend also had I guess she went on Amazon and bought like a notary stamp, but she's not a notary, but she notarized the deed and the seller docs. We only caught it because it wasn't quite adding up. We couldn't get the other brother's ID, and long story, but it didn't work out. And I was able to contact another attorney who I know who had recently closed for the brother. I saw it in the title records, and I was able to get in touch with him. And he said, yeah, they brought me this contract like 2 months ago, but I said, no, I wasn't interested, but they still tried to pawn it off. So, I mean, relatives can do it to relatives, but yeah, the vacant land scams are the ones that I'm always worried about, because like Alan said, it's an out of state owner. Everything is out of state. How do you know if you're actually dealing with the real seller? And I ask my underwriters this when it comes to entities, right? How do you know you're dealing with the actual people in charge of the entity, right? I mean,
Yeah.
it's an entity. It's not like you have social security numbers and IDs for drop ship or whatever LLC or whoever it is that is attempting to sell the property.
And the wire fraud also is out of hand, and you just have to be hyper vigilant. We had a notary take the remote closing package over to a copy scan place, FedEx or Kinko's or whatever they're called. And apparently someone in that facility who was conducting the scan got the information and attempted to redirect our wire from the seller over to them. So
Wow.
they're getting crafty.
Yeah, I haven't seen that much most of the title fraud I've run into has usually involved family.
Yeah.
Um, the but my thought is that it has to be going on quite a bit because I keep hearing commercials all over the place, of selling things that help prevent against title fraud and everything else. But it's a process for sure. If you don't have assistance to buy, a fraudulent deed doesn't unwind itself. And that's going to be a process. And until that's fixed, title companies are going to have a problem moving forward with that. I have another question. What about protection acts? I'm not familiar with what this question is getting at. Do you guys know what a protection act is? No, I think so. Another question. Have you guys ever done a constructive notice? Or I
Here we
guess
go. Yeah, on Tuesday, fraudulent scheme involving vacant and unencumbered. As I'm saying, like I keep getting these bulletins to Alan's point, like regularly. So clearly there is something going on somewhere in the nation with respect to this.
yeah. Yeah, it's out there for sure. Another question, have you guys ever done a constructive notice? The better way to maybe ask this is, what is constructive notice? Anybody want to tackle that?
For title, constructive notice is recording the deed, recording the lien. It's not actual notice; it's constructive notice. I don't know what the question's getting at exactly, but there's a choice between actual and constructive,
Yeah.
and the recording the records is constructive.
Yeah.
Right. And just be aware, your recording in the records is not constructive notice to everyone, right? So if you're involved in a bankruptcy proceeding, even though it may be in the records and it may be constructive notice, even if it's defective, as to, right, in a typical transaction, a bankruptcy trustee is going to be a heightened bona fide purchaser for notice. And even if they have actual notice, if you didn't meet the statutory requirements, at least in Georgia, they can ignore that security deed because it did not actually provide notice since it was defectively executed, which caused a huge flub up here because again we changed our attestation and acknowledgement laws in 2015, and that took down a couple of security deeds and turned those lenders into unsecured lenders. So constructive notice is not the same for all people. Some people are special.
There you go. Well, guys, with that, we've hit about all our questions. I don't want to keep anyone else's time. You guys have been gracious and sticking with us, and we've got one more question. Well, I'll get this. What is an attorney's opinion? So, an opinion letter is a letter that sometimes a lender might ask an attorney to provide to give their opinion on a particular matter. And I don't usually like to do them because they're not easy to do, and it seems like I've got to qualify everything, and there's risks associated with doing an attorney opinion letter. Alan, do you get into that often?
You hit the nail on the head. It could be the simplest. Hey, we just need an attorney letter, and we need them to say these three things. Well, how do I know these three things? And it's just rabbit hole after rabbit hole after rabbit hole. So I'm 100% in agreement with you. I hate them.
Yeah, I've never liked them. What about you, Drew?
So I have a lender who doesn't always buy policies because you're talking about short-term bridge, small, and they just want, a PTO, preliminary title opinion, and a final title opinion. And it's worth exactly what you pay for it. Because here in Georgia, there's two different kinds of opinion letters, right? There is the lender in commercial transactions, you're right, and it's highly structured. And we actually have, again, Georgia has standardized a lot of things. We have like standard rules with respect to those kind of opinion letters, right? And they're a lot of work, and I also don't like them either. But when it comes to instead of getting a commitment in a title policy, right, they may just want an opinion on title. Those, I got a paragraph that says this thing is worth exactly what you paid for it. So just be aware that sure, we looked at title, but there's no insurance, right? If you paid me like, a few $100 for it and it turns out I was wrong, well,
Yeah.
that's what you're getting back.
Yeah. Yeah. Good stuff. Well, everybody, that is it. Thanks for your time. And we'll plan on getting together next time.
Good seeing y'all.
All right.
Awesome.
You
Thank
guys
you,
have
everyone.
a good one.
Happy New Year.
You
I don't think I've
too.
seen y'all since the New Year.
Yeah.